Well, there isn't a single Albertan or person anywhere really who can say that their lives weren't affected by the COVID-19 pandemic. It has changed a lot about the way that we interact with one another, what we perceive to be public health, and for many, it's changed our perception of political power versus civic responsibilities and rights. So joining me today is attorney Leighton, who has been instrumental in ensuring government and corporate entities are held accountable for the pandemic measures that cost Albertans so much. He joins me now. Thank you so much for coming on today, Leighton. Great to have you here.
Well, thanks for that kind introduction. It's a pleasure to talk to your viewers.
Okay, so now before we get into details about Justice Grant Dunlop's recent declaration, tell me a little bit about the cases that you've been fielding since the pandemic started.
Well, there have been quite a few, and it's kind of morphed through different stages. In the early part, we spent a lot of time fighting COVID tickets, and we had a series of high-profile cases involving, for example, Pastor James Coates in Edmonton. Many of your viewers will remember the triple barricading of the Grace Life Church that was occupied by RCMP, turned into a barracks. So we represented him. We also represented Timothy Stevens, a Calgary pastor who was jailed and who was fully acquitted. And we also represented hundreds of people in Manitoba, British Columbia, the Yukon Northwest Territories who faced these COVID tickets and quarantine tickets. But more recently, our firm has become very involved in fighting vaccine mandates involving large employers, many of whom are government regulated, including CN, CP, Canada Post, Purolator, ATCO, and others. The big case that I've been working on with Jeffrey Rath, who's a lawyer in Calgary, is on behalf of the Justice Center for Constitutional Freedoms. It's a case called Ingram. And Ingram is probably the most significant constitutional case, and perhaps the most important civil litigation case that is before the Court of King's Bench in Alberta right now, because the result in that case will impact many, many others. And we've been working on that case since December of 2020. And right now, we're just awaiting a decision in that case from Madam Justice Romaine, who has been the assigned trial judge.
Okay, and I understand that you had the opportunity to question Dr. Dina Hinshaw on a couple of occasions. So what came of those testimonies? What information was presented there?
Well, there were a number of things that came out, but the most shocking thing and the most important thing for the purposes of our discussion today is that when myself and Jeff, when we questioned Dr. Hinshaw about her orders, she surprisingly disavowed ownership of them, which is surprising because when the governor of Alberta declared the emergency, they did not declare a public emergency in the sense that every single arm of government would have a say in what went on, and nor would there be any oversight by the legislature. And instead, they declared a Public Health Act emergency, which essentially set up a medical dictatorship. And I mean that literally. The wording of the statute says that Dina Hinshaw, the Chief Medical Officer of Health, could use any means necessary to fight the pandemic. So when she was asked about these orders, she did something that was rather surprising and very, very significant in terms of the case and the law in Alberta. She said that these were not really her orders, that she was really just the messenger or the transcriber, and that she was going to then Premier Kenney and Cabinet to seek instructions about what to put in those orders, so that they were not her orders. She was just an unelected official, and that these orders actually represented the will of the elected officials in the Alberta government. That was quite surprising. And of course, we found out, we argued in Ingram, that was actually illegal. It was outside of our authority to do that. And then, of course, in another case, in the CM case, Mr. Justice Dunlop said precisely that.
Okay, yeah, you mentioned that. So maybe tell us a little bit about the Ingram case and how that differs from the CM versus Alberta case that Justice Dunlop is hearing.
Well, the Ingram case is broader in scope than the CM one, but ultimately they dovetail to the same legal result. In the Ingram case, Rebecca Ingram is a lady, she's a gym owner in Calgary, and she is like many Albertans, she had her business shut down due to COVID-19 lockdowns. Jeff Rath represents her. I represent some churches through the Justice Center for Constitutional Freedoms, whose religious liberties were infringed. And so we alleged in the Ingram case both violation of certain charter rights, including life, liberty, and security of the person, and also freedom of religion. And we said that these lockdown orders, that they were a violation of the Canadian Charter of Rights and Freedoms and therefore illegal, and that they should be struck down. We also argued that the way that the orders were made under the Public Health Act was illegal because it exceeded the authority of Dr. Dina Hinshaw. And we say that because under the Public Health Act, the whole point of declaring a Public Health Act emergency, and incidentally, there was no prior precedent for a province-wide Public Health Act emergency. Normally, these are local in nature. But the whole purpose of that was to set up somebody who was a medical expert to make these decisions and to formulate these orders. And so it defeated the very purpose of a Public Health Act emergency to have a scenario set up in which the so-called medical expert, Dr. Hinshaw, was going to lay people like the Premier and the Cabinet to get instructions about what to put in health orders. And our suspicion is that the reason why this was done is that Premier Kenney and the government set up Dr. Hinshaw as a straw person who would sort of take the slings and arrows of public scorn, and that they could sort of pull the strings behind the scenes, and that Dr. Hinshaw would ultimately be the one whose names went on the orders. The orders themselves, the wording of them was, I, Dr. Dina Hinshaw, Chief Medical Officer of Health, hereby order. It was so that part of it was very clear, but the part that your viewers need to understand is that in law, this is very significant. Dr. Hinshaw was not permitted under the Public Health Act to delegate the authority over the making of those orders. She had to make those herself. And as I said, the whole idea of her going to the Premier and Cabinet, it defeated the entire purpose. And as Mr. Justice Dunlop in the CM case found, it was fundamentally illegal. So flash forward to the CM case, which was heard earlier, actually a few months ago, and the decision came out recently. The CM case was brought by a group of parents who were concerned about another health order that was made by Dr. Hinshaw back in February of this year, which removed masking in schools. Your viewers will remember this. This is during the period when the then government of Alberta was gradually removing the COVID lockdown restrictions, right, coming out of the Freedom Convoy, the truckers convoy. So what these parents complained about was that they actually said that they argued that the charter rights, that the life and liberty and security of the person of their children was being violated by this order removing the masking, because it exposed them to a heightened risk of being infected or suffering serious consequences as a result of the COVID-19 virus. They also, in that case, claimed, as we did in Ingram, that Dr. Hinshaw had exceeded her authority under the Public Health Act. Well, Mr. Justice Dunlop, in a very well-reasoned decision, dismissed the idea. He said there was no evidence that there was a charter violation, that these children were exposed to an increased risk of COVID-19. However, he did say that under the Public Health Act, it was improper and illegal for Dr. Hinshaw to go to the Premier and Cabinet to get instructions about what to put in these orders. And in that case, in the evidence, very shockingly, and some of your viewers may have heard about this, we heard about a PowerPoint presentation that Dr. Hinshaw actually gave to the Premier and Cabinet about what their different options about what they could do in terms of removing restrictions. And there was sort of a Goldilocks and the Three Bears type of scenario where, we could let it rip and remove all the restrictions, or we could keep everybody locked down, or there'd be this graduated removal of them. And of course, we all know what transpired in the aftermath. But that PowerPoint presentation is very clear and cogent, uncontroverted evidence of this relationship, where Dr. Hinshaw was going to Premier and Cabinet seeking instructions about what to put in these orders. But under the Public Health Act, that simply is not permitted. So the import of this is very significant for Ingram, because when the Dunlop decision came out, the decision in CM, we immediately contacted the court in the Ingram case and said, well, you know, these two situations are really very, very similar. In fact, they're indistinguishable in law. And we think that Justice Dunlop's decision binds you, and that therefore we ought to win in Ingram. In other words, that the court in Ingram should come to the same conclusion. Because whether restrictions are being removed or whether they're being imposed, the same process in terms of the formation of these health orders was being followed by Dr. Hinshaw and the Alberta government. And so we have made submissions, as did the Alberta government, to the court, and we're just waiting. We're waiting the court's decision right now. And that decision is going to have very, very significant impact upon Albertans, because if we are successful in Ingram, that would mean that every single one of Dr. Hinshaw's orders, all those lockdown orders, were illegal. And of course, I think your viewers can put together and connect the dots in terms of the significance of that when you consider all of the businesses that were closed and everything else.
It seems very important and something that could have massive impacts into a lot of other civil cases.
Oh yes, and there are many I believe there are hundreds of cases that are awaiting the result in Ingram. Many of them COVID tickets and the like. But there are many people, as you know, lost their livelihoods over these
Absolutely.
lockdown orders,
Yeah.
and so there is potential, great potential for significant civil liability against the province over these lockdowns, and it's all turning upon this Ingram decision.
It's
So we'll wait and
fascinating.
see. We're waiting with bated breath. We're looking forward to the result, but I honestly did not know how it's possible for the court in Ingram to sidestep or avoid the reasoning of Mr. Justice Dunlop. As I've laid it out, the cases are really, they both turn on the same legal issue. And as your viewers may be aware, there's a principle called stare decisis, which means that our courts are expected to decide similar cases in similar fashion. That's how we have, consistency in our law. Otherwise, we'd have chaos. We have cases all over the place. And so judges tend to be deferential towards decisions that are made in similar cases by judges at the same level of court. In this case, both of these decisions, CM and Ingram, are in the Court of King's Bench, which is the highest trial court in Alberta.
Fascinating stuff. Now, Leighton, I know you've been involved in a lot of employment cases as well as being intimately aware with the details of Pastor Tim Stevens' case. You mentioned that, of course, at the beginning of the interview. So he's, of course, the Calgary pastor who was jailed for 21 days in March for holding church services and has recently been acquitted of all charges. So what should all Albertans and Canadians be aware of in these important matters?
Well, the Stevens case is a great lesson in that he stood out of the crowd. He stood up for what he believed in, and I don't say this to be critical of other Albertans. I understand why many people were afraid and confused and didn't really know how to react to this incredible government overreach. But I think when we look back retrospectively in hindsight upon, how certain people, very brave people, dealt with this government encroachment upon rights and freedoms, I think there's a lot to be learned there. And I hope that Albertans will look upon people like Timothy Stevens and Pastor Coates and Archer Pulaski and Chris Scott and people like that, and be encouraged, and encouraged in the true sense of the word. And in other words, to take courage from what other people have done by stepping out of the crowd. It's understandable, it's human nature just to go along to get along. And in Canada, by and large, we've been very well governed for a very long time. But I think it's important for every Albertan and really every Canadian to begin to question that, because I think COVID-19 is a shining exception to the overall excellent government that Canadians have enjoyed throughout our lifetimes. COVID-19 is a very, very dark period, and I'm one who advocates very strongly for a full public inquiry into the way that governments handle the COVID-19 inquiry. And I think this is very important. For example, as you know, some people are calling for a general amnesty. But I think before we can get to that point, I think we've got to ask some very serious questions about how and why things were done. And I think that everyday Albertans and Canadians have to have the opportunity to come forward and tell their stories. I think this is extremely important in terms of healing some of the damage that was done. And so I think the best thing that could come out of the COVID-19 pandemic, if we're indeed out of it, is to have a full public inquiry into the who, what, where, when, why, and how, so that we can fully document that and learn from it. And that might result in certain people being held responsible, but I don't think that's the most important thing. I think the most important thing is to document what occurred and then chart a course forward to learn from the mistakes that were made, because as we all know, there were many.
We are about out of time here, but thanks so much for sharing your thoughts with us today, Leighton. Appreciate having you on.
It's my great pleasure. Enjoy your day.
That was attorney Leighton Gray of Alberta. You can find out more by checking out his firm's website or by following his podcast, Gray Matter, available online.